Okay, folks, I need you to sit down for this one because something extraordinary happened on Friday, December 19th, 2025. The Supreme Court, the conservative Supreme Court that Trump largely shaped, the court that gave him sweeping presidential immunity, the court that has sided with his administration about 24 times on the emergency docket, ambushed him with a ruling he absolutely never saw coming. The court sided with immigration judges against Trump in a decision that legal experts are calling the administration's first real loss at the Supreme Court since April. Let me set the scene. Immigration judges, who are technically Justice Department employees but are supposed to maintain independence in their rulings, have been fighting a Trump administration policy that restricts what they can say publicly. The policy categorically forbids them from speaking publicly in their personal capacities about immigration and about the agency that employs them. These judges sued, arguing the policy violates their First Amendment right to free speech. The Trump administration wanted the case thrown out of federal court and sent to administrative agencies that, by the way, Trump has systematically dismantled by firing their leadership. Here's where it gets important. In May 2025, the Supreme Court allowed Trump to fire officials at the Merit Systems Protection Board and the National Labor Relations Board, the very agencies that would handle the judge's claims. So sending the case to those agencies would essentially kill it, because Trump controls who runs them. The Fourth Circuit Court of Appeals saw this problem. They sent the case back to the trial court for fact-finding, explicitly noting that Trump's firings of the special counsel and the chair of the Merit Systems Protection Board have called into question whether the administrative scheme for federal employee claims remains independent of the president. Translation: Trump broke the system that's supposed to protect federal workers, so maybe we shouldn't force federal workers to use that broken system. The Trump administration freaked out. Solicitor General D. John Sauer, yes, the same lawyer who argued Trump could order SEAL Team 6 to assassinate a rival and be immune, came running to the Supreme Court asking them to freeze the lower court ruling. Chief Justice Roberts initially agreed to an administrative hold, temporarily blocking the trial court from proceeding. Everyone thought, here we go again. Another win for Trump on the emergency docket. But then Friday happened, December 19th, 2025. And the Supreme Court issued a brief order saying, no. At this stage, the government has not demonstrated that it will suffer irreparable harm without a stay. The court sided with the judges. The case can proceed in federal court. The administration lost. There were no noted dissents. Even the conservative justices who've been rubber stamping Trump's actions looked at this and said, you haven't proven you need emergency relief. Law professor Stephen Vladek, who tracks these cases obsessively, said this was Trump's first real loss at the Supreme Court since April. Think about that. From May through December, Trump won approximately 24 times on the emergency docket. 24. And then this. Why does this matter? Because it's not just about immigration judges and speech restrictions. It's about Trump's systematic purge of the federal workforce and his attempts to consolidate power by firing anyone who might exercise independent judgment. Trump has fired nearly 100 immigration judges since taking office. He's fired officials at independent agencies created by Congress specifically to be insulated from presidential pressure. He's working to undermine those agencies for months, as CNN put it. And the Supreme Court just said, wait, maybe we need to look at whether you've destroyed the system that's supposed to protect federal workers. Maybe we shouldn't force employees to go through administrative channels that you control. This is a crack in the dam, folks. A small crack, but a crack nonetheless. Because for months, the Supreme Court has been enabling Trump's consolidation of power. They gave him broad criminal immunity. They've allowed most of his firings. They've sided with him on immigration, on federal funding freezes, on virtually everything. But this one time, they looked at what he's doing to the federal workforce and said, no, not so fast. We need more information. The lower court can proceed with fact-finding. And Trump, he never saw it coming. He thought the Supreme Court was his. He thought the conservative majority would protect him no matter what. He thought wrong. The decision has possible implications for federal workers more broadly as the justices simultaneously weigh whether to formally expand Trump's legal power to fire independent agency officials by overturning job protections enshrined in a 90-year-old decision. So while the court considers giving Trump more power to fire people, they're also allowing a case to proceed that questions whether he's already abused the power he has. This is the ambush. Trump walked into the Supreme Court expecting another easy win, and he got handed his first real loss in 8 months. Now, let's be clear, the court also signaled the administration could return if the lower courts move too fast. They're not slamming the door entirely. They're being cautious, but they're not giving Trump the automatic stay he wanted. And that matters because it signals that maybe, just maybe, there are limits. Maybe Trump can't fire everyone, destroy every independent agency, consolidate all power in the executive branch, and expect the Supreme Court to rubber stamp it all. The immigration judges are represented by the Knight First Amendment Institute at Columbia University. Their case is simple. We should be able to speak about immigration issues in our personal capacity without government approval. That's what the First Amendment means. And the Trump administration's response is no. You work for us. We control what you say. And any challenge to that control should go through agencies we control. See how totalitarian that sounds. See how it's not about protecting government interests, but about silencing anyone who might criticize immigration policy. The Supreme Court saw it too, and for once, for the first time in months, they said, this is the ambush Trump never saw coming. From the court he thought he owned. Let me tell you about the Supreme Court's emergency docket under Trump's second term, because understanding the pattern of wins makes this one loss even more significant. The emergency docket, sometimes called the shadow docket, is where the Supreme Court acts quickly, without full briefing, without oral arguments, often without signed opinions. It's supposed to be for true emergencies. But under Trump, it's become something else entirely, a way for the administration to implement radical policies while legal challenges play out. During the first 100 days of Trump's second administration, district courts issued approximately 25 universal injunctions blocking his policies. 25. That's an extraordinary number, suggesting that trial judges across the country appointed by presidents from both parties are finding Trump's actions likely unconstitutional. But here's what happened. Trump's lawyers ran to the Supreme Court again and again, asking the justices to stay those injunctions while appeals proceeded. And the Supreme Court said yes. Over and over, approximately 24 times since May, they've sided with Trump on immigration detention, on birthright citizenship procedural issues, on federal funding, on firing independent officials, on virtually everything. The administration has been so successful on the emergency docket that legal scholars started warning about the court abdicating its responsibility to check executive overreach. They warned that the court was using highly technical and narrow procedural decisions to avoid directly confronting Trump's unconstitutional actions. And then came the universal injunction decision in Trump v. Casa Inc. on June 27, 2025. This was supposed to be Trump's crowning victory. The court ruled 6-3 that federal district judges lack the power to issue universal injunctions, orders blocking a policy nationwide. Trump thought this would kill all the challenges to his birthright citizenship order. If judges can't issue nationwide injunctions, then maybe his order could take effect in some states even if blocked in others. But Justice Sotomayor saw through it. In her 44-page dissent, she pointed out that the court's decision left the door open for broad challenges to the president's order, either because a blanket ban on the enforcement of the executive order may ultimately be necessary to provide relief to the states contesting the order or through class actions. And before the day was over, immigrants' rights groups filed a class action lawsuit on behalf of all babies whose citizenship would be affected by Trump's order. They found a workaround, because that's what happens when authoritarian actions meet creative lawyering. People find ways to protect constitutional rights. But the point is, Trump won that case. He won on the technical procedural issue of universal injunctions, just like he's won approximately 24 other times. Until Friday, until the immigration judge's case, until the Supreme Court looked at what Trump is doing to the federal workforce, systematically firing anyone who might exercise independent judgment, and said, we need to know more about this before we give you what you want. The significance isn't just that Trump lost. The significance is why he lost. The court said the administration has not demonstrated that it will suffer irreparable harm. Think about that standard. Irreparable harm. That's what you need to show to get emergency relief from the Supreme Court. And for months, Trump's lawyers have been convincing the court that any delay in implementing his policies causes irreparable harm. District court blocks your deportation policy? Irreparable harm. We need an emergency stay. District court blocks your funding freeze? Irreparable harm. We need an emergency stay. District court blocks your funding freeze? Emergency relief. District court questions your firings? Irreparable harm. Stop the lower court immediately. And the Supreme Court kept saying, yes, you've shown irreparable harm. Yes, we'll grant emergency relief. Yes, we'll stay the lower court order. Until this time, when they said, actually no, you haven't shown irreparable harm, the lower court can proceed. What changed? What's different about this case? I think it's the stakes. The Fourth Circuit explicitly raised questions about whether Trump has destroyed the administrative system that Congress created to protect federal workers. They pointed to his firing of the special counsel who would handle employee complaints. They pointed to his firing of the Merit Systems Protection Board chair who would review those complaints, and they said, if the president has broken the system that's supposed to protect workers, maybe we shouldn't force workers to use that broken system. That's a direct challenge to Trump's authoritarian consolidation of power. That's the court saying, we see what you're doing, and maybe, just maybe, there are constitutional limits on it. And even the Supreme Court, even the 6-3 conservative majority that Trump largely shaped, looked at that and said, we need more information before we shut this case down. The decision also touches on the case the justices are currently weighing, whether to formally expand Trump's power to fire independent agency officials by overturning a 90-year-old precedent. So the court is simultaneously considering two things. One, should we give Trump more power to fire people? And two, has he already abused the power he has by destroying the systems that protect workers? And they've decided they need to answer question 2 before they decide question 1. That's extraordinary. That's judicial caution in the face of executive overreach. Now, I don't want to overstate what happened here. The court left the door open for the administration to return if the lower court moves too fast. They're not delivering a crushing blow to Trump. They're just saying, not so fast. Let's get some facts first. But in the context of 24 straight wins for Trump on the emergency docket, even this limited loss is significant, because it shows that maybe, just maybe, there are limits to how much the Supreme Court will enable autocracy. The immigration judge's case is represented by the Knight First Amendment Institute, and their framing is powerful. This is about free speech, about whether federal employees can speak in their personal capacity about matters of public concern, about whether the government can silence anyone who might criticize policy. That's First Amendment 101, folks. The government can't punish employees for speaking on matters of public concern in their personal capacity. That's been settled law for decades. But Trump doesn't care about settled law. He doesn't care about the First Amendment. He cares about control, about silencing dissent, about ensuring that no one in the federal government can publicly question his policies. And for months, the Supreme Court has been letting him get away with it, letting him consolidate power, letting him destroy independent agencies, letting him purge the federal workforce. Until Friday, when they said, actually, maybe we should look at what you're doing before we rubber stamp it. That's the ambush. That's the loss Trump never saw coming from the court that's given him everything else. But wait, there's more. Because while everyone is focused on the immigration judge's case, there's another Supreme Court surprise lurking in the background, one that could cost Trump's administration and American taxpayers up to $168 billion. The Supreme Court is set to rule on Trump's authority to impose tariffs using emergency economic powers. And here's the twist. It's not looking good for Trump. Let me explain. When Trump returned to office in January 2025, one of his first moves was imposing sweeping tariffs on dozens of countries using the International Emergency Economic Powers Act of 1977, IEEPA. This is a law designed for actual national emergencies like wars or terrorist attacks. Trump used it to impose tariffs, lots of tariffs. Through December 5, 2025, the U.S. government has collected $259 billion in tariff revenue under these emergency powers. As of November 17, the overall effective tariff rate in the U.S. was 16.8%. the highest since 1935. That's not a typo, the highest tariff rate since 1935, since the Great Depression, since before World War II, and it's all based on Trump invoking emergency powers that legal experts say he doesn't actually have the authority to use for trade policy. A trade court ruled that Trump's imposition of tariffs based on IEEPA was illegal. The Federal Court of International Trade upheld that ruling. The Trump administration appealed to the Supreme Court asking for expedited review. The court agreed and heard oral arguments in early November, and here's the kicker. During those arguments in November, the Supreme Court seemed divided over whether Mr. Trump had the legal authority to impose sweeping levies under IEEPA. Divided, not solidly behind Trump, divided. If the Supreme Court rules that Trump illegally invoked IEEPA, that he didn't actually have the authority to impose these tariffs, the government would be required to refund approximately $168 billion to importers who paid the tariffs. $168 billion, with a B. That's according to analysis by Kent Smetters, a professor at UPenn's Wharton School. The government has collected $259 billion, but roughly $91 billion came from tariffs imposed under statutes that aren't being challenged. The remaining $168 billion, that's the emergency powers tariffs, the ones the lower court said were illegal, and if the Supreme Court agrees, Trump's administration has to give it back. Think about what that would mean. It would be a hit of billions on the Treasury, as one analysis put it. It would likely derail any plans the president has about abolishing the income tax, which Trump has floated as a possibility. More importantly, it would be a direct rebuke of Trump's claims to sweeping executive power. It would be the Supreme Court saying, "No, Mr. President, you don't get to invoke emergency powers whenever you want to implement your preferred trade policy. Congress gave you limited authority, you exceeded it, and Trump, he's trying to bully the Supreme Court into ruling his way." In defending his tariff actions, Trump asserted, only dark side and sinister forces would want to see that economic strength end. Read that carefully. Trump is saying that anyone who rules against his tariffs, including Supreme Court justices, is on the dark side and represents sinister forces. That's the President of the United States threatening the Supreme Court, saying rule for me or you're evil. As one commentator put it, translation, beware of people in black robes who may be harboring sinister thoughts about ruling against you. But here's the thing, the Supreme Court doesn't take kindly to being threatened. They don't like presidents questioning their legitimacy or calling them sinister. Even conservative justices tend to get their backs up when the executive branch tries to intimidate them.